good evening, everyone.
Good evening, sir.
Okay, the topic that we'll be addressing today is contracts in practice, as especially as they relate to intellectual property. I'm sure all of you have probably some elementary understanding of contracts in general, but let us look at two things today. One is principles related to interpretation of contracts. We look at some case studies and we'll also look at some recommended approaches. Okay. The idea of the conversation is, of course, to try and keep it as practical as possible and as specific to real world scenarios. Okay. Now, how many of you are familiar uh, between Saideep and Deepak? How many of you are familiar with the subject interpretation of contracts?
It is an interpretation of contract in related to any subject or only IP related?
Any subject, any subject.
No, interpretation related to the any contract like construction contracts, consultancy contract that I am familiar, which
Okay.
I am doing.
Okay.
Interpretation of statutes. Are you talking about interpretation of
No, no,
statutes?
no, not statutes, contracts.
Not familiar, but would like to give it a try.
Okay, sure. So why don't Saideep, why don't you take a shot at maybe giving me three principles of interpretation of contracts, and then Deepak, you can probably share maybe two or three insights from your experience with construction contracts.
Yes, sir. Thank you for the opportunity. Sir,
Sure.
interpretation means some changes, some necessary changes which should be done in contracts. For example, the changes which are necessarily needed but are facing some legal hurdles. So by what you say, by by placing those legal hurdles in a board meeting or anything and getting a consent about the contract regarding any contract and what you say, clearing the hurdles in a easy stage,
Okay.
it can be it may be called as interpretation of contracts.
Okay. Thank you for that attempt.
Thank you.
The interpretation of contracts is slightly different, right? So when we talk about interpretation of statutes, it is about how you read a statute. Similarly, when we talk about interpretation of a contract, we're talking about how to read the clauses of a contract. Okay. It doesn't necessarily deal with the issue of hurdles and how the contract can be made to overcome those hurdles. Here, we are only talking about whether the plain and unambiguous language of the contract should be read, should the context and the purpose of the contract be considered, similar to how statutes are interpreted and read as per different rules, like the literal rule, the golden rule, etc. For contracts also, there are different principles governing how a contract must be read and understood. Okay. Deepak, do you want to share maybe an insight or two about how a contract is to be interpreted?
Every contract should be enforceable, legally enforceable by law.
Fair enough. Okay, that's a principle of contract itself. I'm talking about interpretation of a contract. How do you read and understand a contract clause? Okay, never mind.
I think contract clauses are, already support is to be defined that what I have to follow all the to obligation under the contract. Means if something I have to done, I have to obliged by that. What are the rules and responsibility as a party?
Correct. So that is a contractual obligation. I'm talking about slightly different. So, for example, if let us assume that there is a word used in the contract which is not very clear, how do you then interpret that word? Never mind. Yes, ambiguous. So, never mind. We'll go into that in some detail. But understand, for the purposes of this conversation, it is important to recognize that the interpretation of contracts, like the interpretation of statutes, is a distinct subject. What principles you apply for reading a statute cannot be applied for reading a contract, and vice versa. You can't apply the principles of applicable for reading a contract to reading a statute. Okay. So today, more than the IP aspects, we will be dealing with the principles of how contracts are read, understood, and therefore enforced. Okay, because ultimately you have to deal with a judge or an arbitrator who will decide how the contract is to be interpreted and enforced. So if you don't keep in mind principles of interpretation, then you might end up in a situation where the intentment of the contract is understood differently by the arbitrator, and therefore the purpose is not met. Okay. So we look at interpretation of contracts.
Dispute related.
Not just dispute related. Not just dispute related, generally, because how do I put this? So, for example, you look at a sale agreement. Okay, now the sale agreement dealing with an immovable property will have a recital clause. Why do we have a recital clause?
Mhm.
It is based on interpretation of contracts. There will be a clause dealing with the deadline for completion of the sale deed. Whether time is of the essence or not is again a question of interpretation of the contractual clauses. Okay, so like I said, if you have dealt
Okay.
with the interpretation of statutes where you're taught how to read a statute, for example, saying that, and I accept the text of the law, you can't read anything more, or the purposive rule of interpretation, which says what is the object of the law. Based on the object of the law, you read the law accordingly, right? So sometimes you may have to interpret it liberally, you have to interpret it conservatively. So we need to keep those principles in mind so that when we are drafting the contract or reading a contract, we're reading it correctly. Okay. So then we look at some recommended approaches and
Okay.
we'll also look at some case studies to help you understand how this works in reality. Now, the very first thing that you need to keep in mind is that the governing law or the law that governs the contract will define how the contract is read and interpreted. Okay. So to give you a simple example, when we look at a contract which has governing law as English law or Indian law, you cannot read anything more than the contract in front of you to understand what the intention of the parties were and what was the intended rights and obligations of the parties under the contract. Okay. So sometimes what would happen is a clause would have been put into the contract, but the parties would have exchanged WhatsApp messages about how what the contract is supposed to be, how this particular clause is to be interpreted, what the supposed meaning of the clause is. But under Indian law, as also English law, anything that is not stated in the contract is irrelevant. You can't look into it to determine the meaning of the contract. Okay. So in case of ambiguity, for example, sometimes you may be tempted to say, okay, let's see what the parties have discussed around the contract or this particular clause to see what they understood by this ambiguous term. But Indian law and English law says you can't do that. You have to go only by the contract and nothing else. Okay. But if you're dealing with, say, French law or German law or civil law, right, or countries which are dealing with the civil code, there you can not only examine the text of the contract, but you can also refer to the negotiations around the contract, the messages exchanged, the emails exchanged, any conversations that the parties have had as to how an ambiguous term has to be understood and interpreted. So all that is available to you. But under Indian law and English common law, you can't examine anything more than the contract itself. Okay. So the first step to understanding how a contract is to be drafted or interpreted is to figure out what is the governing law that will apply to the contract. If it is English common law or Indian law, lot of emphasis is then given on ensuring abundant clarity within the language of the contract itself. Because you will thereafter not be able to go outside of the contract to understand what the parties were supposed to do. Whereas in other legal systems, the contract language is the starting point. But you can look at a whole bunch of other things to examine what the contract is supposed to be, how it is interpreted, and how it is enforced. Okay. So the first step is governing law. Clear so far? Any questions? Okay. Saideep, any questions? Okay. Now, then also the question of jurisdiction, right? So, where are you going to be eventually enforcing the contract? Which country and which city? What are the dynamics specific to that particular forum for enforcement? What is the average understanding of the English language in those particular regions? Will also then define how the contract is actually drafted. Sometimes when you know that where the contract is going to be enforced, it is not a forum known for very good English acumen, then you will necessarily have to simplify the language of the contract, right? And bear in mind one thing: there is a misplaced, understanding amongst everybody to say that the more complicated the language of the contract, it is a really good contract. It is the exact opposite. A contract must be drafted in the most simple of language so that it is easy for somebody to understand and figure out what the parties actually intended to do together. Now, in the context of IP, though the statute might grant you recognition of IP rights, be it trademark, copyright, or it could be common law recognition such as the duty of confidence, it could be passing off. What converts the IP right into money is the contract in between, whereby you will either license or assign the IP involved. If there is no contract, then monetization of that idea will become very difficult. Now, what is to be kept in mind? The first thing is contract is communication. So, and I can't stress this enough. And if I have to take a very crude example, oftentimes in the context of our own families, you will see how we say one thing and the other person understands something else. Correct? It must have happened to you a lot of times where you intend something, but the meaning that is understood by the other party is completely different, right? Now, that situation is something that we need to keep in mind when it comes to a contract, because you might be very clear in your mind as to what the contract is supposed to do in terms of the rights and obligations. But if you don't put in the kind of effort necessary to place those ideas on paper correctly, using very clear language, then you're likely to be misunderstood by whoever has to enforce the contract. Okay. So there can't be enough emphasis on this. Do not make the mistake of downloading templates of the internet and just making some changes here and there and signing it. It can't be done that easily. It requires a lot of thought to decide what are the specific context of the parties entering into the contract, what is the purpose of the contract, what is sought to be achieved, so on and so forth. And thereafter, you go into the subject of how to draft the contract. Now, for the purposes of interpretation of contracts, you need to keep the following principles in mind. First principle, a contract is to be interpreted keeping in mind what is the intent of the parties executing the contract. Okay. So, is that point clear? Essentially, it means that if Deepak and I enter into an agreement, Saideep has to interpret and decide who is right and who is wrong, or who's got an enforceable right or obligation. Then Saideep must inquire into what was the intent of Deepak and Ashok when they entered into this agreement. He will ask that one question to himself: what were their intent? Now, the next question is, how is he able to gather that intent? Because intent is in the mind, right? So, the law of interpretation of contract says that the intent of the parties, as captured by the language of the contract, is the basis for Saideep to decide what is the intent of Deepak and Ashok to enter into the agreement. So, when that question arises in Saideep's mind, what is the intent of Ashok and Deepak? He will pull out the contract, he will read the clauses of the contract. Based on what is written in that contract, only he can guess what the intent is. He cannot ask Ashok or Deepak to say, forget the contract, you tell me what you intended. That is not permissible. Okay. Now, the third point to keep in mind is when a contract is being read and interpreted, okay, it is not read and interpreted keeping what Ashok understands or what Deepak understands, because we have intricate personal knowledge of the contract. So a judge or a third person cannot ask Ashok or Deepak what they intended when they entered into a contract. Some stranger to the contract who has no idea of what Ashok and Deepak intended, who has no background to the transaction, who is absolutely a complete stranger to the transaction, he or she, what they are able to gather when they read the contract, that interpretation alone will prevail. Okay. Ashok's explanation of the clauses, Deepak's explanation of the clauses will not make any difference. It will only be the language of the contract alone, as understood by a person who's a complete stranger to the agreement. How he or she understands the contract will then decide what the contract terms and conditions are. Okay. Anything else other than this under English common law or Indian law is not permissible. Now, there are several theories behind this. Okay. The third principle, very important. A contract can have only one meaning. Okay. It can't have Ashok's meaning and Deepak's meaning. That is not permissible. It can only have one meaning which Deepak and Ashok jointly intended, which is understood and interpreted from the point of view of a notional third party stranger who has no idea of the subjective intent but only reads the contract to gather that information. Okay, so this is the three or four cardinal principles of interpretation of contracts. Okay, now you can't go beyond these principles along with the various other principles applicable. The construction or the interpretation must be a reasonable interpretation. It must appreciate and give effect to the commercial intent of the parties. These are the relevant principles of interpretation of contracts. Okay. When you're drafting the agreement, therefore, you would have seen, for example, sometimes, especially in construction contracts, a definition clause, which will define what the terms in the contract are. Now, why there is a definition clause? Because the parties drafting it would have realized that tomorrow it has to be understood and interpreted by a complete stranger to the agreement. And there should not be a doubt in his mind as to why a particular word was used in the contract, because what he understands will ultimately define the fate of the parties. So that's why a separate definition clause is incorporated into an agreement. Okay. So you'll have to keep in mind the object of the contract, which is the purposive theory that is in front of you, right? And then you'll have to keep in mind the object theory, which says that you can't go beyond the language of the agreement. And last but not the least, there's a subjective theory which says what is the subjective intent or understanding of the contracting parties. That will not be relevant for purposes of Indian law and English law. Okay. Now, one of the things you will then understand and appreciate is that you don't know who the notional stranger to the contract is who will be called upon to interpret and enforce it. Because at the time of execution, you don't know who that is going to be. So if you end up using language which is very, very complicated, which is a very flowery language, things that will require a dictionary to be kept aside and then frequently referred to, you have already done a bad job with the agreement. Because chances are that the person who has to read and interpret the contract may not have that level of familiarity with the English language. So keep in mind these two things when you're putting together an agreement, generally and specific to IP. You need to have clarity of thought or clarity of mind, and you need to have simplicity of language. Long paragraph, long sentences, very, very lengthy agreements, bad idea. Okay, any notion that tells you that the contracts have to be very large, very complicated with multiple, repetitions of the same things, don't go by that. That's a bad lesson. You need to have clarity of mind and simplicity of language. Okay, I can't stress on this enough. Any questions so far? Okay. Now, governing law for the contract also impacts the IP involved because a lot of times IP in one jurisdiction is not recognized in the other jurisdiction. To give you a simple example, database rights in the European Union is not specifically a different right in India. Okay, it will probably come under the general copyright law. So trade secrets, which trademarks which are unregistered are recognized in India, but they may not be recognized in a civil law forum or a forum that believes, for example, in the Sharia. So you have to remember that what governing law you choose will then decide whether the IP right involved is even enforceable or not. And sometimes you, even in the context of a patent, you could have a business method patent that's recognized in the US, but it is not recognized in India. So then if you're doing an elaborate licensing agreement where you say that the business method will not be, utilized except through the agreement, and it's an Indian recipient, he will take your idea and he will start using it. And you'll have to later come and try and find a way to enforce it because the business method patent isn't even recognized in India. So the other thing also is that the governing law will require certain things of the IP licensing or assignment agreement. For example, under copyright, it is important that all forms of licensing or assignment are captured in writing. Oral contracts are not recognized. Similarly, when it comes to trademarks, which are conveyed without goodwill, it is important that for registered trademarks, the deed of assignment is registered with the Trademark Office as per the Trademarks Act. If you don't register the deed of assignment conveying the trademark without goodwill, chances are that the assignment will not be binding and effective. So always remember that governing law or law will play a heavy role in the IP right recognition. So when you download a template of the internet and try to use it in your trademark assignment or copyright licensing, a lot of these nuances you may not even examine. So it's very, very important that when you have an IP licensing or an IP assignment or any kind of contract related to IP, you first ask yourself the question, what is the IP? Second, you ask yourself the question, what is the law governing the IP? Third, you ask that question, under the law, if I have to do a contract around this IP, what are all the do's and don'ts and what are all the strengths and limitations? If you don't end up making this inquiry, then you will probably end up affecting the fundamental basis of the transaction, which is the IP, right? And then also what happens is it will impact your remedies and reliefs because a lot of times, for example, you might have a clause that says liquidated damages is payable when there is a breach of the license agreement for IP. But the problem is that under Indian law, even if you have liquidated damages stipulated in the agreement, you still have to prove actual losses under Section 73 of the Contract Act. So merely because you have it there, it may not really fetch you the money that you're looking for. Secondly, when you have to go and get an injunction for preventing the theft or the infringement of your IP, one of the things you have to prove is irreparable harm and injury, which means that the harm and injury occurring to you is not something that can be compensated by way of money. But if the contract itself says that, listen, if there is a breach of the contract around the copyright, you will get XYZ sum of money as damages, which is considered to be a genuine pre-estimate of damages for such breaches, then the irreparable harm and injury argument flies out of the window because you have yourself admitted that the nature of the injury is compensable by way of money. So depending upon what the intentment is and what the objective is, you have to decide what kind of clauses you want to put in the contract, keeping in mind how the law will affect both the IP, how it will affect the right to relief. Okay. Now, like we were discussing, the first question, we already had those checklists. What is the IP? What is the law governing the IP? How the law will impact the IP, so on and so forth. The next question that you have to ask yourself is what is the context of the parties? Because sometimes you may have inequality of bargaining power, where one person is in a superior bargaining position and the other person does not have the right to bargain. So, a best example I can think of is employer employee. When you join a company as an employee, you get a standard form letter of employment. You can sit and negotiate whether or not you actually have a right to amend or modify the terms of the employment. So a lot of times when it is a case where it's a standard form agreement, the courts tend to be a little careful or a little restrained in enforcing those agreements because they feel that there is inequality of bargaining power. There could be chances of undue influence. Similarly, contract signed between a doctor and a patient is presumed to be involving the undue influence. Same thing with a mental health counselor and his client, right? So between a spiritual guru and a devotee. So all these are instances when the law itself says that the consent is vitiated by undue influence. So you need to understand the context of the parties and ensure that you're drafting a fair agreement so that tomorrow when you go to the court of law and you have to try and enforce it, you can preempt an undue influence defense by saying that look at the contract, it is so fair to both the parties. How can any person come back and say that this is actually a product of undue influence, right? So this is one thing that needs to be kept in mind when it comes to drafting a contract. Make sure that you capture the context of the parties correctly. Ensuring enforceability becomes important, especially in terms of being able to avoid the pitfalls like undue influence. You need to also supply context to the meaning of the terms. Right? So, for example, a lot of times you may have a situation where you say that if so and so person, ends up generating any idea in the course of employment, that idea will automatically belong to the employer. Now, it might seem, though it is a well-recognized principle and it's a product of the statute itself, but one person may come and ask if the employee is generating the idea, why should the employer have it? But if you in the contract itself, if you explain that the sole motivation for the employee generating the idea is the compensation that is being paid by the employer to him, or is the compensation being paid by the client to the contractor, then you can come back and justify saying that this idea would not have even come to his mind if not for the fact that I was paying him money. So when you capture that context, it makes it easier to explain some of the clauses that might seem favorable to one party and not favorable to the other, because there is a rationale there that seems ethical and logical. Okay. So ensure that there is a fairness that is in the contract, which is very important to ensuring that the contract is A, enforceable, and B, there is less incentive for the parties to breach the contract when it is reasonable. Okay. Now, the second thing is you need to keep the business case in mind. What is the commercial intent or the objective of the parties entering into the agreement? That also becomes very important because ultimately the whole purpose of the contract is the realization of the benefit. Third, we have to recognize whether the business case is tenable or not. For example, if a film producer is getting a copyright license in respect of a book and he says that the book author is waiving off his moral rights, that business case is not viable because the law says that moral rights cannot be surrendered. So you can then have to come back and say that I'm not assigning my moral rights. I'm only agreeing not to enforce my moral rights against you. That business case will be tenable. It is enforceable. Similarly, a lot of employment agreements in the technology industry says that after you leave the company for a period of 1 or 2 years, you can't work with a competitor. Now, it might seem like a contractual clause, parties might have even agreed to it, but Section 27 of the Indian Contract Act is absolutely clear. It says that such a non-competition clause is not tenable, right? You can't enforce it against an ex-employee. You can only enforce it against the current serving employee. So you have to keep in mind what the specific business case is, then ask that question whether that business case is even enforceable as per law, and then go about drafting it. Right? Now, in addition to all of this, you also have to keep one thing in mind. Sometimes there are specific requirements for the contract under relevant statutes. Like I said, for assignment of IP rights under patents, trademarks, or copyright, there's a requirement of registration sometimes. So you need to ask yourself whether under a specific statute there's a requirement applicable to the IP. That you'll be able to answer when you identify the IP and then ask that question, is the IP covered by a law? A lot of times, state legislations also require you to pay stamp duty And if you don't pay the stamp duty, then the agreement can't be produced as evidence. So if the agreement can't be produced as evidence of the rights and obligations, then what's the point? So you'll have to also check what the stamp duty payable is. Ensure there's fairness in the contract, as we discussed. Ensure there is clarity of the language. Okay. And in today's day and age with ChatGPT and Gemini and so many other tools that can help you refine the language, we have absolutely no excuse to come up with a shoddily drafted agreement and then expect the courts to come back and not question the way in which it is drafted. Right. So take care, ensure that you use the tools necessary, including AI, but make sure that the contract language is simple, clear, and coherent. Okay, now the thing also is that IP is not static, it evolves. Okay, so for example, let's look at it this way. Let's take a clause of an employment contract which says that whatever is the improvement of an idea that comes in the mind of an employee for the company's product also belongs to the employer. Okay. Now, I'm an employee of one such company. I signed this clause. I worked there for about 2 years, and then I have picked up the entire skill set. Okay. So let's take contracts as an example. I have picked up the skill set to draft an agreement. Now, at the end of 2 years, I realize now that I have certain hacks. I can do the contract drafting exercise at half the time with 90% more accuracy. Okay. Because of the fact that for 2 years I've done contracts over and over and over again, I have developed as a lawyer, right? I can do better work faster. Now the agreement says that whatever is the idea that you generate or the ideas that you retain in your unaided memory is something that will belong to the employer. Imagine how ridiculous it will be once I leave the employer, go to a different company where I start using those contract drafting skills, only for the previous employer to now come back and say, you can't use those skills anymore, right? Those skills belong to me. So in those circumstances, it may not be tenable to have that derivatives clause there in that same form and manner. But there are times, for example, where there are certain ideas that could potentially qualify for protection. Like if you've generated ideas for a code for self-driving cars, and you want to take the code is in your mind, you can recreate the code anytime you want. But you join a competitor, then the derivative clause makes sense because it is essentially raw information which you had already were supposed to surrender to your previous employer, but you've gone to the competitor and you may take that raw information in your unaided memory. That will not be possible because the courts will say, sorry, that belongs to your former employer. It has to stay there. Okay. So when IP changes hands from my hand to somebody else's hand, in the hands of the new individual, it is likely to go through improvements. It can go through modifications. How do you address that? Right? Because the background IP or the raw IP that I gave has now become foreground IP. It has become improved. It has become modified. It has become a different creature altogether. So that your contract must essentially address, right? So, and also to be able to draw the distinction between the raw IP and the improved IP, because you don't want the raw IP to be surrendered in favor of the guy making the improvement. You may not want to surrender even the improved version of the IP, saying that whatever improvements you make belong to me. But all these aspects must be captured in the agreement dealing with the IP itself. If you don't address this, then tomorrow you'll have contingencies where the question will be, who owns the foreground IP? Who owns the background IP? What is the difference between the background IP and the foreground IP? What is the valuation to be ascribed? All those things need to be preempted in the form of the agreement. Now, let's take an example, right? A simple non-disclosure agreement. I'm sure all of us would have probably come across this at some point of time or the other. So you will have to capture the context of the parties and the agreement in the recitals. You will then define what is the confidential information or the trade secret. You will then capture the reason or the purpose for which the parties are exchanging information. You may then want to also identify what happens to the raw trade secret that is exchanging hands, and what happens to the improvements that occurs at the hands of the person receiving the raw trade secret or the confidential information. And then you may also have to address things like non-competition and non-circumvention, where you say that the person receiving the IP will not use that IP to compete with the business. Right. So this concept of these principles of interpretation of contracts, when you apply it to this case, for example, we have defined what the confidential information is, so that a stranger to the contract has absolute clarity as to what the information being exchanged can be. Second, the purpose theory. We have mentioned what is the purpose of the agreement by defining the business case. Okay. And then we have also gone to the level of detail of describing what the raw IP is, what happens to the improvements over that raw IP. This is perhaps one of the many examples that you can think of where the theories of interpretation of contracts can be seen in practice. Right? Any questions? Now, when it comes to licensing and assignment, the business case permutations and combinations are infinite, right? It can be exclusive, it can be non-exclusive. So the person receiving the license or the assignment may receive it exclusively or on a non-exclusive basis, where you give it to him and you also give it to some 100 other people. You can limit it to sectors and regions, especially when you look at copyright societies like Novex or IPRs and so on and so forth. What you notice is that sometimes license is given for bars and restaurants to one copyright society, but license is given to somebody else for, say, gymnasiums and healthcare and fitness centers. So the same IP, one person has rights for one particular sector or market. The other person has a right over a different sector or a different market. It can also be region specific. One person gets it for, say, Karnataka and Tamil Nadu. Other person gets it for Uttar Pradesh and Uttarakhand. One person may get it for India. One person may get it for, say, Belgium. One person may get it for all of Asia. One other person may get it for all of Europe. It honestly depends upon depends upon the parties to decide what are the permutations and combinations around the sectors and the regions. What is the consideration, right? Is it a basis of royalty sharing? If royalty sharing is stipulated, how will the proceeds be accounted for? Will the royalty be calculated on the gross earnings or on the net earnings? All these things need to be specified within the contract. What is the licensing fee or the assignment fee? And then you also have to address statute specific requirements. Like we discussed, for example, about how some statutes will require registration. Okay. Now, especially in the context of copyright, there are very, very nuanced rights. Now, when you take a look, for example, in a film, right, a feature film, and what's a recent feature film that we can think of? I'm sorry, what are the cinemas that are releasing in the cinema? What are the films that are releasing in the cinemas recently? Let's take War 2 as one of the examples, right? Now, War 2, if you look at the film as a whole, it is not one single copyright, right? In that, for example, you might have music and lyrics. Now, lyrics is a distinct category of copyright. Musical composition is a different category of copyright, right? And then the singer who's singing the song has performance rights, right? Similarly, there could be, say, Anil Kapoor who's starring in the movie as one of the characters, and Anil Kapoor might have certain publicity rights. For example, his famous line from his yesteryear days, where he would say "Jackass." Now, the Delhi High Court has recognized that as a distinct form of publicity right, which is also IP, whereby no other person can utter the same line in the same manner as Anil Kapoor without his consent, right? So there is also publicity rights. Now, for the film script, there is it's a literary work, so there's a distinct right in that. Then there is the dialogues, which is again a distinct literary work or a dramatic work. Then there is the entire movie itself, which is a cinematograph film. So you have 4 or 5 different categories of copyright. Now, within that, you will have broadcasting rights, where you give the right of broadcast to somebody, right? It could be a television channel like Star, Z, or Sony. It could be perhaps an OTT platform like Netflix or Amazon Prime. So essentially, when you're drafting the agreement for the various kinds of rights that a producer has to acquire, you have to first identify all these distinct categories of rights appearing in the movie and then draw up contracts for each category of those rights to come to the producer. So therefore, when the producer is paying money for say the lyricist, the music composer, the actors, the script writer, the director, the cameraman, so on and so forth, he is actually getting his money's worth in terms of aggregating all these different categories of rights. And then the aggregated right, he can then go to a broadcasting platform and say that, look, Sony, you get the right to put it on your television channel, but not on your OTT platform. OTT rights, I'm going to give it to Amazon Prime. So when you realize the sheer number of permutations and combinations that are possible, what you understand is that the statute is only the foundation. It is just the basic premise of the IP monetization exercise. The Copyright Act is the beginning point. But these contracts is essentially very critical to ensure that what is recognized in the statute actually generates money for the concerned individuals. Now, you also need to obviously look at dispute resolution forums. Where are you going to enforce the contract if something goes wrong, right? Who will have jurisdictional court? whether you want arbitration or no arbitration. If arbitration, whether you want a three-member arbitral tribunal, sole arbitrator, more than three, all those things have to be determined. Everything has dynamics associated with it. A three-member arbitral tribunal might become very expensive, right? A sole arbitrator may be less expensive. Sometimes a court of law may make more sense because, especially when you're dealing with IP rights, there are certain categories of IP rights that are arbitrable, and there are certain categories of IP rights that are not arbitrable. So, a lot of IP contracts, you'll be probably better off not going to an arbitral forum and instead specifying a conventional court of law jurisdiction. So, for trade secrets and confidential information, because it's intricately linked to the confidentiality agreement, it might make more sense to enforce it as part of an arbitration clause. So, these are things that you'll have to really think through before you decide how the dispute resolution forum works. Because each dispute resolution mechanism comes with its own challenges, comes with its own advantages. Okay. Now you'll also have to figure out what kind of interim measures that you'll be needing, injunctions, damages, specific performance, so on and so forth. What about the costs that the parties are likely to incur? Based on that, whether the court is more convenient or arbitration is more convenient. Convenience of the parties. If one party is in Delhi, the other party is also in Delhi, it makes no sense to say that the arbitration will be in Bangalore, right? And a lot of times, because templates are downloaded off the internet, I have even seen situations where two Indian parties choose the laws of New York as the governing law and the courts of New York as the enforcement forum, when both of them are in India and the transaction is in India, merely because they've copied the template without modifying it. Right? And then you have to look at the arbitrability of the dispute. Like I said, certain categories of IP rights are not arbitrable. So you'll have to then decide whether the arbitration clause is even desirable or not. And if it is for whatever reason arbitrable, like for example, a licensing agreement, which is arbitrable, then you will have to also figure out which arbitration forum to choose, because now you have institutional arbitration centers. London Center of International Arbitration, London Court of International Arbitration, Dubai International Arbitration Center, Singapore International Arbitration Center. You have a Mumbai Arbitration Center, Delhi, Bangalore. Each of these places has its own arbitration center. Depending upon the competence of the arbitrators, the cost, the quality of services you get the arbitration centers, whether they have adequate conference rooms, whether they have transcription facilities, whether they have adequate staff, how expensive is it going to be? So based on that in your contract, you'll have to decide what is the forum for dispute resolution as well. Okay, now coming to the concluding aspects, remember clients will come and tell you what the basic fundamental bullet points of the transaction are. As a lawyer, it is not your job to act as a stenographer and just document whatever your client tells you into the contract. You have to help temper those ideas. You have to bring in your own counsel. You have to sometimes calibrate, validate, or invalidate certain ideas that the parties have wrongly negotiated. So there's a big difference between saying, client told me this is the transaction, I'm going to put it as it is, to saying, I will actually draft the agreement. Drafting of the agreement requires application of mind. It is not just recording information from the client and throwing it on paper. Okay. Now, second, a fair contract equals successful completion of the transaction and lessening of legal risk. Unfair contracts, fundamentally difficult to enforce. And two, could invite the risk of breach. Now, second, the value of a contract is always defined by a variety of factors. But one of the main things that influences the value of a contract is obviously the simplicity of the language and the clarity of the thought. And the fourth point, there is always a better way to put across a clause in a contract. When you're drafting it, never see the clause and be happy saying, oh, I've done a great job with this clause. Keep asking yourself, is there a better way to say this? Is there a better way to say this? Is this simple enough? Or can I simplify it some more? Right? So you'll have to really make that effort and not take it for granted. Spend time on the contract. Don't download a template, change the names, change the date, and get it executed. That is laziness. It is the most condemnable part of a lawyer's work when you resort to templates. Do not make that mistake. And last but not the least, there is a lot of scope for innovation these days. For example, we're already seeing the concept of contract visualizations, where contracts are now being drawn up as a cartoon, right? Where you have chat boxes coming out of the characters explaining to each other what they mean by the contract. You have audio visual contracts, you have smart contracts in the form of blockchain enabled smart contracts. So, and a lot of times now, especially going forward, when courts start using artificial intelligence increasingly for assisting judges, you may have to make the contract more machine readable. Therefore, having the contract clauses drafted in such a simple manner that even an AI will be able to quickly read the agreement and tell the judge what the fundamental crux of the transaction is. right? So that effort to constantly innovate must be also constantly there. You can't ever say, okay, I've learned contract drafting, I don't have to innovate anymore. So keep these principles in mind, because that is going to be critical to ensuring a successful IP contract. So my contact information, thank you very much. If there's any questions, I'm happy to take it now. Okay. Stuti, can we
PPT will be available into that?
yes, I'm happy to share the PPT. Yes, Saidip.
Sir,
Okay.
some questions from my side. Can you share some templates for the reference purpose?
Sure. We are putting together a library, right? I'll be happy to share those contract templates with all of you.
Yeah, regarding IP trademark, such templates, if shared, it would be very helpful for
Sure,
me.
sure, sure, sure,
Okay,
sure,
thank you.
sure. Okay. All right. Thank you. Thank you, gentlemen. Take care.